Hello everyone. I hope I am audible and visible to everyone. So finally we have come to the topic murder and culpable homicide. Now we discussed culpable homicide yesterday. Culpable homicide basically this is culpable homicide not amounting to murder. CHNAM. Okay. Let me just give you a revision of what we did yesterday. So we discussed culpable homicide yesterday, which is defined in section 299 and which says whoever causes death with the intention of causing death, that is intention, then with the intention of causing bodily injury, causing bodily injury as is likely to cause death, then third situation was knowledge. Knowledge of what? That act may cause death. Okay. In the language of Bare Act, with the knowledge that he is likely by such act to cause death. Okay, so if he had the knowledge that the act which he is doing may result in death. So these were the three circumstances mentioned in section 299, that is culpable homicide. Okay, now we have to discuss section 300 now. And also I told you that in order to prove murder, always culpable homicide needs to be proved. Okay, you directly cannot prove murder. Firstly, you will prove culpable homicide and then we go into murder. Okay, now let's just first give a direct reading of section 299 and then I'll just once again will give you a brief about it and then thereafter we will be starting with section 300. Okay, just a sec. Okay, so let's come to section 299 first once again. Yes, so section 299 talked about whoever causes death. What does it say? Whoever causes death by doing an act. Remember, here they have mentioned by doing an act. I relate today it to murder. Okay, so remember this thing. Whoever causes death by doing an act with the intention of causing death. Okay, so yesterday also I told you that this is the first part of section 299. Then, or with the intention of causing bodily injury as is likely to cause death. Okay, now here intention to cause bodily injury is mentioned and not intention to cause death. Remember this thing. The intention which will be examined here is whether he had the intention of causing bodily injury. Thereafter we will call whom will we call? We will be calling doctors or we will be seeking expert opinion under section 45 Evidence Act. And this becomes part 2. Remember yesterday I told you that bodily injury will be examined independent of the act of the accused. Okay, whether that bodily injury was enough to cause the death of the accused or to cause the death of the victim. Remember? Then we came to third part, or with the knowledge that he is likely by such act to cause death, commits the offense of culpable homicide. Okay, where is offense defined? First class 40. Okay, and here from here we have the third part of section 299. Okay, done, understood. Now let's give a bare act reading to section 300. Look, section 300 murder. It starts with except. They are stating first of all, they are stating except in the cases hereinafter accepted. Okay, except in the cases hereinafter accepted. Culpable homicide is murder. Okay, culpable homicide is murder. If the act by which the death is caused, what have they mentioned? If the act by which the death is caused is done with the intention of causing death, is done with the intention of causing death. So I just now told you na that we have to focus upon the here. And in section 299, we focused upon an act. Here it was mentioned whoever causes death by doing an act. And in section 300, they have mentioned by doing the act. Here, culpable homicide is murder if the act by which death is caused is done with the intention of causing death. So the necessary implication of section 299 part 1 and 300 part 1, it is basically 1 because from here we have secondly, thirdly, fourthly. So here it must be firstly only as it is related to section 299 1. It directly relates to section 299 1. So in order to look, what have they mentioned here in section 300? First leave this part. Leave this part. Just read this from here. Culpable homicide is murder. Okay. If the act by which death is caused is done with the intention of causing death. Okay. So it necessary means that section 299 1, which talked about intention of causing death, straight away if someone is able to prove section 299 clause 1 that he had the intention of causing death, then automatically it will come under section 300 and the punishment will be under section 302. Okay, if section 299 is proved, look, now section 299 1, they say intention, whoever causes death with the intention of causing death. So the accused has intention to cause death, right? And intention is the highest degree of mens rea. Remember the 3 kinds of mens rea which I talked about: intention, knowledge, reason to believe. Right? Okay. Now we'll compare it to section 301. Here also they have mentioned intention. Culpable homicide is murder if the act by which death is caused with the intention of causing death. Intention to cause death. Right? Here. Culpable homicide is murder if the act by which the death is caused is done with the intention of causing death. So this means section 2, if section 299 clause 1 is proved, automatically section 301 will be proved, and in such a situation culpable homicide will amount to section 299 1 will directly amount to 301, and the punishment will be under section 302. Okay, are you guys following? Okay, now this thing is done. So if section 290, I told you yesterday, right? If these are the two blocks, this one is culpable homicide and this one is murder. 299, 300. Prosecution always first prove culpable homicide. Okay, always culpable homicide is proved first. If culpable homicide is proved, only then murder can be proved. Why so? Because the definition says so. Look again, they are specifically stating that culpable homicide is murder if the act by which the death is caused is done with the intention of causing death. Okay, have you understood? Right? Now let's read section 302. Okay, secondly, culpable homicide is murder if it is done with the intention of causing such bodily injury as the knows offender knows to be likely to cause the death of the person to whom the harm is caused. Okay, then we have thirdly. In thirdly, we have if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. Okay, so in section 302, in section 303, they are basically talking about bodily injuries. And which part of section 299 talked about bodily injury? Tell me. Which part of section 299 talked about bodily injury? Yes, it was section 299 2. So, in order to make yes, so in order to make someone liable under section 300, what needs to be proved? First, culpable homicide, which is defined in section 299, it needs to be proved. Once culpable homicide is proved, then we will come to section 300, that is murder. Okay. If culpable homicide is not proved, murder cannot be proved. Okay. So we were talking about section 299 to bodily injury and its relation with section 300 secondly and thirdly. Okay. Bodily injury. Now in section 299(2), it basically talked about intention to cause bodily injury. Okay. It just talked about intention to cause bodily injury. Okay, if the accused had the intention to cause the bodily injury, then it in the second, basically I told you yesterday also that section 299(2) can be further divided into two parts, right? First one is we have to examine whether the accused had the intention to cause bodily injury. Thereafter, the second part will be whether that bodily injury, whether the bodily injury is likely to cause death. Okay, is likely to cause death. Here we will see mens rea of accused, but here we will seek medical opinion or expert opinion. Expert opinion as defined in or as talked about in, tell me, section 45 of Indian Evidence Act 1872, right? Indian Evidence Act 1872. Okay, just a minute. Okay, so section 299(2), once we came into section 299 clause 2, and we have like proved that it is section 299 clause 2 which is applicable here. That is, we have proved the MR, that is mens rea of accused, and we have proved that the medical opinion also suggests that the injury, bodily injury, which was inflicted by the accused is likely to cause death. Once these two are fulfilled, basically if these two are proved, then we'll move into section 300. And since we have bodily injury here, since we are coming from section 299 clause 2 which talked about bodily injury, therefore we will examine now section 302 and section 303. Okay, so in order to prove section 303 or section 304, we first of all, what do we need? We need section 299(2) first. That is the first and the foremost requirement. And why so? Because the Bare Act says so. As simple as that. Except in the cases hereinafter accepted. Culpable homicide is murder if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused. And thirdly, culpable homicide is murder if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. Okay, let me give you an example of section 302. If 303 needs to be proved plus here offender knows here plus if the bodily injury is sufficient. Knowledge, rather they don't talk about knowledge here. They just tell us if bodily injury is sufficient in the ordinary course of nature to cause death. Okay, now for offender knows, let me give you an illustration here or an example. Suppose there is A and B. B is suffering from a disease of say swollen appendix. Okay, what happens in this disease is the appendix that is near your stomach area, it gets inflamed. So if this inflamed area is pressed or is punched, if someone gives a severe blow here, then it is likely that it will cause the death of the person. Okay, it is likely that this will cause the death of the person. Now, yeah, swollen spleen, swollen appendix. Appendix is also called as spleen. Okay, now A with this knowledge gives a severe blow or a punch, gives a punch to B on that area only. Now this is bodily injury. Okay, whenever you see bodily injury, first need to examine section 299. Since it is bodily injury, you will directly come to section 299 too. Since it is bodily injury, you need to come to section 299 too. Section 299(2) says with the intention of causing bodily injury. Okay, once intention of causing bodily injury is proved because he gave a punch, obviously he had the intention of causing the bodily injury. Now medical expert will be called whether that bodily injury is likely to cause death. Okay, it was a severe blow and severe blow at the area of swollen spleen. Yes, it is likely to cause death. Proved. Now, if these two are proved, then section 299 is proved. Okay, section 299(2) is proved. Therefore, okay, let me first explain it with reference to section 299(2) only and its relation with 300. Okay, here once the expert opinion says that yes, it is likely to cause death, then we'll come to 300. Since it is bodily injury, first part will not be examined. What will be examined? Secondly, what says? Secondly says the offender knows or had knowledge that harm may cause or is likely to cause the death of the accused, death of the victim. Since section 302 talks about offender's knowledge. Now, here, did A, when he gave the punch, did he had the knowledge of this disease, that's B is suffering from a disease of swollen spleen or swollen appendix, and if he gave a tight blow or a punch here at this area at near the stomach area, then it will cause or it is likely to cause the death of the victim of B in our case. The answer is yes. The offender knew about the disease. So since section 299 2 is proved, and when we examine section 302, knowledge is also proved. Knowledge is also proved. So we'll say that the accused is liable under section 302, that is punishment for murder. What is this? Imprisonment for life or basically it talks about first death, then imprisonment for life plus fine. Okay, have you understood? Tell me. I'll explain once again. Don't worry. $299 plus if knowledge of offender, culpability under requirements of section 302 are proved, culpability under section 302, which are death, imprisonment for life plus fine. Okay, imprisonment for life plus fine. Now whether death will be he will be made sentenced a capital punishment or not, these depend upon case to case and circumstances to circumstances, and also the judicial mind of the judge. If it falls in the rarest of rare cases, then maybe death may be sentenced. And if it does not, then imprisonment for life is there plus fine. Now, what happens in if like suppose section 299 clause 2 only was proved, that is accused had the intention to cause bodily injury plus the bodily injury is likely to cause death. What would have happened here if knowledge of the offender, look here, intention had to be proved only for the bodily injury, not for this. Intention was required to cause the bodily injury only and not other than this. For this, we need expert opinion whether the bodily injury is sufficient to cause death or is likely to cause the death to cause death. For this, we need medical opinion. And the require once these two are fulfilled, then we move to section 302 or 3. Since in our case, A had the knowledge of the disease, that is swollen spleen, swollen appendix. Then we talked about knowledge also. In order to make the accused culpable under section 302, you have to prove knowledge. But here, in for culpable homicide, you just need to prove intention to cause that bodily injury, not intention to cause the death. For this, section 300 clause 2, we have to prove firstly section 299 2. In that we have two things to be which needs to be proved: intention to cause bodily injury, and that intention is likely to cause death according to medical experts. Once that these two, look, once section 299 2 is proved, that is these two elements are proved, then you can make the accused liable under section 304, that is it is culpable homicide. And what does section 300 tell us? It gives us the punishment for culpable homicide not amounting to murder. Homicide not amounting to murder. This is what section 304 talks about. And here the punishment given is only 10 years. Okay. Now look at the quantum, the difference in the quantum of punishment. Here it is death or imprisonment for life plus fine. Here it is 10 years. Plus fine is also there in section 304. Look, in 304 also they have mentioned about imprisonment for life. But again, it's a matter of judicial discretion. They mentioned about imprisonment for life as well, but it is a matter of judicial wisdom. And normally, if though it depends upon facts and circumstances of each case, normally in culpable homicide, 10 year, if section 299 2 is proved, then only it is 10 years punishment. But yes, they have mentioned about section 3 imprisonment for life as well. Okay, let's read section 304 once. We'll come back to thirdly and fourthly. Section 300, thirdly and fourthly are left. Look, here they mention whoever commits murder shall be punished with death or imprisonment for life, and shall also be liable to fine. Okay. Now, punishment 304. Punishment for culpable homicide not amounting to murder. Here, what does it tell us? Whoever commits culpable homicide not amounting to murder, that is CHNAM, culpable homicide not amounting to murder, shall be punished with imprisonment for life, or imprisonment of either description for a term which may extend to 10 years, and shall also be liable to fine if the act by which death is caused is done with the intention of causing death or of causing bodily injury as is likely to cause death. So in section 304, what are they talking about? They are basically in first para of section 304, they are talking about 299 1 and 299 2. Okay. Then in the second para, what they tell us? Or with imprisonment of either description for a term which may extend to 10 years, or with fine if the act is done with the knowledge that it is likely to cause death but without intention to cause death. If even if they have skipped writing this part, na, it would have been sufficient, because if it would have been with intention to cause death, then we would not have read this part. Instead, the punishment would lie here, right, in 299.1. So they are talking about 299.3. So it is implicit that it was done without the intention of causing death or to cause such bodily injury as is likely to cause death. So they have mentioned basically section 299, 2 and 3 here once again. Okay. So in section here they talked about 299 3, that is knowledge that that an act such act is likely to cause death. Okay. Now, three hundred two. Then let's come to 4.3. No, first, thirdly, if it is done with the intention of causing bodily injury to any person, and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death. Okay. Now, what are they talking about in section 303? Okay. Firstly, again, they are talking about bodily injury. Got it? They are talking about bodily injury. Then they are talking about intention of causing bodily injury. Okay. Then this bodily injury in 302, they talked about knowledge of offender. in 303 they are talking about if bodily injury is sufficient in the ordinary course of nature to cause death. Okay, in the ordinary course of nature to cause death. Now, here again, if bodily injury is sufficient, for sufficiency, what will we examine? For sufficiency, again, we need to call expert opinion. Expert opinion will be seen whether the bodily injury which is caused by the accused is sufficient in the ordinary course of nature to cause the death. Okay, if that bodily injury was not sufficient in ordinary course of nature to cause death, then section 303 will not be proved. It must be proved that the injury which was inflicted by the accused must be sufficient in the ordinary course of nature to cause death. Got it? Yes. Okay. So, if sufficient, then section 303 prove culpability under section 302. Got it? Which is death or imprisonment for life plus fine. Got it? Tell me. Okay. So I am clearing this now. Okay, an example. Okay, sure. 103. Example. Suppose there is A and B. Okay. A was suffering. No, B was suffering from a disease. Maybe again, let's suppose swollen appendix. Okay. Now A gave a punch to B. But he wasn't aware that he was suffering from this disease. Okay. Now you need to suppose here that section 299(2) is proved. Prosecution is able to prove or has been able to prove section 299(2). Then only thing which is left for the prosecution to prove his case and that his case falls in under section 303 is that the bodily injury is sufficient in the ordinary course. Sufficient to cause death. Now, whether a punch will lead to death of a person, tell me, whether a punch can lead to the death of a person. Right. A simple punch can never lead to a death of the person. Right. So punch, simple punch which led to the death of the person will not make him liable for 300 unless and until the accused had the knowledge. If he had the knowledge, then his case will fall in section 302. If knowledge, if he was aware that he had a swollen spleen, then this case will fall in 302. It will be proved. But since he did not have the knowledge, so this part will not be proved. The prosecution will not be able to prove this part. And since this part is not proved, the case will not fall in section 300, third part, not fall here. Hence, culpability will be under section 304. That to which part? Since it is bodily injury and section 299 1 section 299 2 talks about bodily injury and section 304 para 1 talks about bodily injury and intention to cause death, wherein they have mentioned that the person may be liable, can be made liable for death, imprisonment for life, and uh, fine. So here the accused can be made liable for punishment for life or death plus fine. Normally, it does not happen that death is awarded in the cases of culpable homicide, but yes, they have mentioned in the cases of rarest of rare cases. But I have never come across a case where culpable homicide is proved and the person was awarded or made culpable under section 304 and he was given death sentence. I never came across such a case. Okay, normally 10 years imprisonment is, if the prosecution is not able to prove 300, then 10 years imprisonment is given to the accused. Okay, now we are done with section 303. Now let's come to section 304. Let's see what does it say. Look, section 300, fourthly, it talks about if the person, look, you have whenever you read Where Act, always try to read it like this. Culpable homicide is murder. Then, if the person committing the act knows that it is so imminently dangerous that in all probability it must cause death or cause bodily injury as is likely to cause death, and commit such act without any excuse for incurring the risk of causing death or such injury as aforesaid. Okay, here the stabbing example which I gave you yesterday can aptly be applied, because in that case the person gave a stab with a knife. This knife was a slightly longer one. We can, instead of knife, maybe uh, what we say. Instead of knife, maybe it was a kripal. Okay, thus kripal of six, the 5 Ks. Kesh, Kanga, Kada, Kripal, Acha. Okay, 5 Ks wala Kripal. He gave us stab with Kripal. Then the act is so eminently dangerous that it is likely to cause death. Then the case will fall under fourthly. If the person committing the act knows that it is so eminently dangerous that it must, in all probability, cause death, as is likely to cause death. Or we can give an example of here we can give an example that if someone pushes another, if A pushes B from the top of the mountain. Look, now suppose A and B are two trekkers or the persons who do hiking, who go on expedition and all. Suppose once they decided that they will climb Mount Everest. Mount Everest. Okay. Now both of them climbed, reached till here. Then what B did was B pushed A. No, A pushed B. What what A did was A pushed B and B fell from here. Suppose his body was recovered. So these things are very circumstantial and it will be very difficult, very difficult to prove that it was A who pushed B because at a height of around 4432 meters, I guess. That's the height of Mount Everest. It's quite unreasonable and unjust that uh, I don't think you will find any witness or any other evidences which can prove that it was A who pushed B. Okay, so these are very circumstantial thing, though they since there is a provision, so we must read it. So death. Now A here knew that his act is so eminently dangerous that in all probability, pushing someone off the cliff, obviously it is a dangerous act, right? And it will, in all probability, will either cause death or will cause bodily injury. Death or will cause bodily injury as is likely to cause death, right? So we have bodily injury here too. So if section 299 2 is proved, then we can make the person liable under section 300. Secondly, 300 third, section 304. We can make him liable under any, right? And section 304 itself directly relates to section 299 3 as well, right? It directly relates to 304. What did section 299 talk about? Does an act with the knowledge does an act with the knowledge that it may lead that it may cause death. Okay, got it? Since they have mentioned about knowledge in section 299.3, so section 299.3 is to be read with section 304, and section 304, section 299.2 also needs to be read with section 304, because section 304 also talks about either death or bodily injury as is like to cause death. Okay, now section 304 is also done. If someone has any doubts, kindly ask me. Otherwise, we'll move forward. Okay, an example. Okay, I will give an example here. Suppose there is a crowd A, B, C, D, E, F. Okay, they are standing close to each other. There is like I have made some gap, but assume that they are standing close to each other. Let me draw it again. A, B, C, D, E, maybe F also. Now there is one G. He has a gun. He fires upon these basically he fires upon this group. Fires. So now examine. First section 299. It whether first examine 299.1. Whether he had the intention to cause death. No, he just fired the gun. Right? He just fired the gun. He did not have any premeditation that he will kill one of those. So how can he make intention? Intention not absent. 299 failed. 299 2. Whether there is bodily injury? No. No bodily injury is there. He directly fired a bullet. There is no bodily injury. Failed. Section 299 3. Knowledge that such an act is likely to cause death. Okay. We have section 293. Knowledge that he is likely by such act to cause death. Now he had the knowledge since he shot upon the crowd. He had the knowledge that such an act is likely to cause death. Right? He had this knowledge. But if we are able to prove this only, he will be made liable under 304 para 2, imprisonment 10 years. Okay, but if the prosecution frames the charge of 304th as well, since the act which he was doing, that is shooting, and that too on a crowd, since he was shooting on a crowd, So what will we say? Since he was shooting on a crowd, so we will say that he had the knowledge that his act is so imminently dangerous. That his act is imminently dangerous. That in all probabilities it will cause death. Suppose gun, since he is shooting with a gun, and that too upon a crowd with a bullet. So this thing is proof that the act is imminently dangerous, and once the bullet hits, there is a chance that, yeah, there is a chance that it will result into that death. So probability is high. Like probability is obviously, if you draw a circle, then in all probabilities does not always mean that this whole circle, if this is mens rea, probability of, in all probability does not always mean that this whole mens rea should be there. Instead, even if this much was there, then also, if this in all probability means, because they are mentioning about probability and not that it must be so that it will cause death. They are just saying that in all probabilities it must cause death. So once G fires with the gun upon the crowd, one of them is killed, then his act is so imminently dangerous that in all probabilities it will result into death. Hence, section 302 proved punishment, death, life imprisonment plus fine, depending upon facts and circumstances of the case and the judicial mind of the judge. Okay, I am removing it now. Section 300 part 4 is done. Okay. Now let's come to the first part, that is except in cases hereinafter accepted. What are the exceptions they are talking about? After accepted. Look, they mentioned hereinafter, except in cases hereinafter accepted. Culpable homicide is murder. Okay, they have not mentioned herein before. What if they had written herein before? If they had written herein before, they must have referred to the general exceptions. Section 76 to 106. This is the section 76 to 95 basically, and then second part we have 96 to 106. 96 just tells us that nothing is an offense done in private defense. Then 97 tells us it takes private defense body, property, right? Then for then we have section 98. What does 98 tell us? Tell me. 98 tell us that if it was a case of 82, 83, 84, 85, etc. 86 also included. Then also person has the right of private defense even if these acts were not offense, because private defense is available only against offenses according to section 97. So even though these cases are not an offense, even then private defense is available. Remember? Then 99, 100 and so on. Okay. 99 talked about. 99 talked about extent or the restrictions. If you can take recourse to public authority, etc., then you must not exercise your right to private defense. Then 100. What did 100 tell us? Death. When does it extend to causing of death? Then 101, 102, 103. Death in order to protect your body, your property. This one is body. 100 talks about body, property. Okay, just revise them again. 102 continuance and when this private right to private defense start, continues and ends. 102. Then 105 talks about when does it extend to it starts, continue and ends in the case of property. Okay, revise them once again, because to be very frank, I also need to revise them. I also tend to forget. Everyone does. Okay, now let's come to 300 again. 300. Except, it starts with except. Except in the cases hereinafter accepted. They are talking about hereinafter accepted. Okay. So, if one of these exceptions is proved, then the case will fall in culpable homicide not amounting to murder. Punishment again 304. Right? Exception 1. It talks about grave and sudden provocation. Okay. Now, suppose the accused or the offender acted under grave and sudden provocation, and this grave and sudden provocation must be done by this provocation must be done by the victim only. Acted under provocation by victim, then it will not be murder, rather it will be culpable homicide not amounting to murder. Okay. Now, exception 2. Now, here they talk about if the offender exceeds his right to private defense. So in that case also, because you can, like I told you in the cases of private defense also, at the time of that, when I was discussing private defense, I told you that you cannot expect the accused to be in that case we studied it with respect to victim, that you cannot expect the victim to measure every act of his or her in golden scale, right? At that time I told you that you cannot expect the victim to act under golden scales and to do every act after measuring it in golden scales. This is a term mentioned by Supreme Court. Okay, that's why I'm mentioning it. So if he does the in that case, here it is the offender. This victim in exception 2 is the offender. Okay. And this here that if the death is without premeditation or pre-planning, there should not be any planning. Okay. Then we have exception 3. Now it talks about public servant must be acting under discharge of his duty. Under duty. Okay. This is the third exception, that if a public servant acting under his duty maybe exceeds uh, exceeds the force or the thing, basically it protects police officers. Okay, so if they exceed the act and causes death, then they are covered under this exception and their case will not fall in murder. It will come to culpable homicide not amounting to murder. Now this whether it will be like whether it will be punishment will be of 10 years, mostly it is of 10 years only. Whenever culpable homicide not amounting to murder is proved, then it is 10 years punishment. Okay, then exception 4. If exception 4 talks about sudden fight, if in a sudden fight someone does an act which leads to death, then it will be culpable homicide not amounting to murder. Simple. These are very simple things. Just a bare act reading would suffice. Though I am not even reading the bare act, but you can read the bare act yourself, or you may ask me if you have any doubts. Exception 5 is basically Again, volantin non-fit injuria. I told you when we read section 87, that was general exception, that no one consent for his death. So basically they are protecting section 87 here. Consent for death or grievous hurt. Okay. So if death or grievous hurt is caused in 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 case death or grievous hurt is caused, basically for culpable death should be caused. So if death is caused and the person had consented for doing for suffering any other harm other than this death or grievous hurt, then what will happen is firstly prosecution will prove that the person has caused death, so he should be convicted because he has caused death. So he suppose the prosecution has been able to prove section 300, one section 299, then section 300. So prosecution has been able to prove section 300 death. Okay, then what will the accused do? Accused will now raise the general exception first, that the victim consented to suffer harm. Okay, but since in section 87 only it is mentioned that no one will consent to suffer death or grievous hurt, right? So this is also mentioned here, exception number 5. So if the accused is not able to prove general exception, if he is able to prove general exception, then what will happen? Tell me what will happen. If the accused is able to prove general exception, then no culpability, acquittal. There will be an acquittal. Remember, if general exception is proved, no culpability. If since section 87 also talks about that no person will consent to his death or grievous hurt, here general exception will not be proved. Now he will come to exception 5 and he will try to reduce his culpability. Basically, he will try to disprove that it was not murder, rather it was culpable homicide. By proving this exception 5, the accused will try to prove that it was culpable homicide. And since it was culpable homicide, so it did not amount to murder. And hence, the culpability which was here in section 302, which was here in section 302, now will get reduced to section 304. Now it will fall in para 2 or para 1 or para 2. That is a matter of facts and circumstances, and it will differ from case to case. If it was with the intention or with the bodily injury, then it will fall in para 1. If it was with the knowledge of the act, then it will be para 2. Okay. Now let me explain you. Now let me make a simple, what we say, chart for you. Okay. Look, if section 299 is proved, either 1 or 2 or 3, either of the part is proved, then we'll come to section 300, either 1 or section 299. 2, bodily injury, intention, bodily injury. 299. 3, knowledge of act, that it is such act is likely to cause death, knowledge. Then section 301, intention. If 299 is proved, 301 is automatically proved. Then 2, bodily injury. What bodily injury plus knowledge of offender. Remember, knowledge of offender. The swollen spleen example, swollen appendix example, punch with the knowledge that he has a swollen or inflamed appendix will result into death. So if knowledge of offender is there, section 299 2 bodily injury is there, plus offender knows that such bodily injury is likely to cause death. 302. 303, if the bodily injury which was caused here, 299 2, which was caused here, is sufficient in the ordinary course of nature to cause death. Sufficient in ordinary course of nature. Sufficient ordinary course of nature. Okay. If it is sufficient in the ordinary course of nature, it will be 303. Course of nature. Then fourthly, if the accused, firstly related to section 299 3, okay, that the accused had the knowledge that such act is likely to cause death. Once this is proved, then if the act is so imminently dangerous that in all probability it will cause death, probability, that it will in all probability will cause death, then it is 304. 304 also talks about a bodily injury, wherein the cliff example, wherein the person threw the other person off the cliff, Mount Everest. Or in bodily injury, we discussed about that act also. Which was that? Uh, the shooting in the crowd example also will fall here. That is, act is so imminently dangerous that it will cause such bodily injury as in all probabilities it will cause death. That in all probabilities it is likely to cause death. That's the language of the Bear Act, right? Bodily injury cause death, or such bodily injury as is likely to cause death. Okay. Now this thing is done. Once you have been able to prove section 299, then section 300. Now the burden of prosecution is discharged. What we say. Now from here we come to accused. If the accused proves that his case falls in any of the general exceptions, person acquitted directly, right? What will happen if, look, this is one situation, acquitted. Now if the person is, if the prosecution has been able to prove 300, 300 any of the part, section 299 any of the part first, then section 300 any of the part, then accused proves any of the exceptions mentioned in 300, which are exceptions 1, 2, 5. If any of these exceptions is proved, case will fall in culpable homicide, not amounting to murder. Culpability under 304. Okay. Now third, what can third be? Third can be that if section 299 1, 2 or 3 is proved, but 300 1, 2, 3, 4 any of them is not proved, case will directly fall in 304, depending upon, now culpability will be depending upon whether it was bodily injury with intention, whether it was the act with intention, it was bodily injury, or with it was the knowledge that his act is such that it is likely to cause death. Now, depending upon if it is intention or bodily injury, then 300 para 1. If it was knowledge that his act is such as is likely to cause death, then it will be section 304 para 2. Okay. So this was about culpable homicide. If anyone has any doubts, kindly ask me. Otherwise, we will wind up the session. This was culpable homicide. Then we discussed murder. Then culpable homicide not amounting to murder. 304. Okay. There is, okay. So okay. So there is one more section, that is 301. It talks about transfer of malice. It is basically transfer of malice. I will explain it, but not today. Let's leave this. Let's call it a day for today. I will surely discuss it someday, because from tomorrow, I think we need to start with kidnapping. Okay. 359, 360, 361, then 362 abduction. Okay. So you may start leaving now. Thanks a lot. Yeah, thanks a lot. Actually, I also get to learn a lot from you guys, because you also have uh, uh, I would say immense knowledge with you, and I myself also learn a lot from you. Okay, you may start leaving. Thank you.